Major breaking news, we have the three-judge panel in the Reno, May, and other quote-unquote sensitive places case in the Ninth Circuit Court of Appeals, and I'm not going to lie to you, it is terrible. It is a terrible panel. We're going to lose almost this entire case involving gun-free zones, government-mandated gun-free zones. There may be a couple opportunities to pick up a win here, but this panel is literally from hell if you support the Second Amendment. Let's break it down when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many books, including Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, we have breaking news. We have an announcement from the United States Court of Appeals for the Ninth Circuit. As you know, there's oral argument on April 11th, 2024 in the cases of Wolford, Carolero, and Reno, May. These are the cases that came out of Hawaii and California involving the quote-unquote sensitive places laws. Sensitive places are euphemisms for government-mandated gun-free zones. These are three cases that are being argued simultaneously or consolidated. It won't break you down with the procedural details, but they're all being argued on April 11th. The panel, the three-judge panel that has to decide this initially, has just been announced as overseeing all three cases, and it is an utter disaster. If you support the Second Amendment, I suspect there may be 1 or 2 points we can win, but overall, we're clearly going to lose given this terrible panel. Let me go through the three judges, and you'll see exactly what I'm talking about. The three judges are Judge Mary Schroeder, Judge Susan Graber, and Judge Jennifer Sung. That's Schroeder, Graber, and Sung. Judge Sung, just to go through the list, Judge Sung is a Biden appointee, does not appear to have had any Second Amendment cases yet, but she graduated from Oberlin and Yale Law. She's a former union organizer. Before being nominated, she signed a letter accusing Brett Kavanaugh of being intellectually and morally bankrupt, an intellectually and morally bankrupt ideologue, and stating that people will die if she's confirmed. That's the infamous petition from Yale Law students and Yale alum. She signed it as an alum and had all sorts of crazy statements in there against now Justice Brett Kavanaugh, stating that he presents an emergency for democratic life, for our safety and freedom, for the future of the country. So that's one of the judges, Judge Sung, now on the Ninth Circuit Court of Appeals because of Joe Biden, wrote a letter attacking Brett Kavanaugh during his confirmation hearing. Not optimistic there. Then we have Judge Graber. Judge Graber, she's a senior Clinton appointee. She's even worse than Judge Sung as I see it. She's been a leading opponent of the Second Amendment out there in the Ninth Circuit. She's one of the, I would say the multiple horsemen of the apocalypse if you support the Second Amendment on the Ninth Circuit. She wrote the en banc decision in Duncan before Bruin, which was before the Bruin decision that upheld California's magazine capacity limit. She also wrote a concurrence to the majority explaining why Heller supported the application of intermediate scrutiny. Did you hear what I just said? Judge Graber, who's on this panel, is so crazy when it comes to the Second Amendment. She actually supports intermediate scrutiny despite Heller, and actually made the argument that the Breyer dissent, the Stephen Breyer dissent in Heller, was really the law of the land. That's insane, but that's exactly the second judge on this panel involving Reno, May, Wolford, and Carolero. Judge Graber also was in the majority in the Peruta case. You may recall that upheld the May issue permitting regime, which is the exact same regime that was struck down as unconstitutional by the Supreme Court in the Bruin case, except that May issue permitting regime that says you're only allowed to have a gun if they deem you should have a gun or you need to have a gun for self-defense purposes. California had the same law out there, and that was the Peruta case, and that was declared constitutional at the time before Bruin by Judge Graber. Useless person when it comes to the Second Amendment. The third judge is Judge Schroeder, who's a senior Carter appointee. You don't find too many Carter appointees out there, Jimmy Carter. Judge Schroeder, though, wrote an opinion on Sylvester versus Harris that upheld California's 10-day waiting period for acquiring firearms. So Judge Schroeder's on the record against the Second Amendment, upholding a 10-day waiting period. So that is your three-judge panel. Judge Mary Schroeder, Judge Susan Graber, and Judge Jennifer Sung. So not good. So as I see it, if I were trying to litigate this case, aside from a New York aggressive trial lawyer approach, which is very mean and nasty, but I'm not going to recommend the lawyers do it out there. If I was arguing, I'd probably be much tougher on some of these things. But again, that's a whole separate issue. The bottom line, though, is this. I think that right now there is probably a possibility to win some aspects of these sensitive places cases. Just a reminder, some of the issues that are presented in these cases involve medical facilities. You can't have a gun in medical facilities. You can't have a gun even with a carry permit in the libraries. You can't have a gun even with a carry permit in zoos, in public parks, and amusement parks, and all the sort of places like that, like public transportation. The one area I think we may still be able to win, which is such a slam dunk case that even the United States Court of Appeals for the Second Circuit in that terrible Antonyuk case decided in support of the Second Amendment. That is the issue of the no carry default that says you're not allowed to carry a gun with a carry permit in any public place unless they post a sign that says guns are allowed. Even the United States Court of Appeals for the Second Circuit has said that's insane and not consistent with the Second Amendment or constitutional rights. That is the one area that I think that Mary Schroeder, Susan Gaber, and Judge Jennifer Sung may rule in our favor, because even the anti-gun courts in the United States have viewed that theory as just too utterly insane that even for the moment they will not accept it as constitutional. That is where I would laser focus and try to prevail. As to these other cases, we clearly should win. If we were in front of the Supreme Court, I think we would win all those elements, all those examples. But given this, given the track record of these three judges, including an attack on Judge Kavanaugh, that she signed a letter where she tried to, in her confirmation hearing, try to explain it away. But again, you can't be signing crazy letters like this as a Yale graduate. This is terrible things about Judge and then Justice Brett Kavanaugh without having read it first. So I'm skeptical of any excuses that Judge Jennifer Sung, a Biden appointee, may have had about that letter against Judge Kavanaugh. But again, I think the odds of any kind of major win here in this motion for a preliminary injunction, which was granted by the lower court, at least in the Reno May case, the idea that this three-judge panel is going to uphold any major part of it, I think, shall we say, I'm skeptical. I mean, anything's possible. You know, we have upsets in the NCAA basketball tournament. Maybe this will be an upset, but I suspect not. I suspect that this will be a terrible decision that the lawyers will then have to make a decision whether or not to try to seek cert on an interlocutory basis, because this will be an interlocutory appeal decision because it's a pending motion for a preliminary injunction. So whether the court will take it, we can have a debate, we can see. But I think there's a good chance that we will simply lose the bulk of this case on sensitive places in California and Hawaii, and it will get sent back to the various district courts for further consideration over the next couple years. That's my best guess. I wish I could bring you great news here, but the truth is, this is, in my opinion, an absolutely crappy, terrible anti-Second Amendment panel, and I hope I'm proven wrong, but I'm usually pretty good at my predictions on some of the stuff, and I think we're probably in for a very difficult day on April 11th, the oral argument, and a more difficult day, months thereafter when they issue their opinion. So there you have it, folks. Breaking news. I don't always give you the happy stuff. I have to give you all the stuff, the good, the bad, and the ugly. And today, when it comes to these three cases of Wolford, Carolero, and Reno May, I think this is ugly news for the Second Amendment. So there you have it. We will talk to you soon. Don't forget to subscribe and resubscribe. We're trying to get to 150,000 subscribers here. Don't forget to follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.